All right, this is 250467 SM, the state of Michigan versus Stephen Haynes.
Jared Grasser on behalf of probation.
Morning, Your Honor. Jeffrey Fant on behalf of Mr. Haynes. There's a violation proposed for a contact violation. We waive formal reading, stand mute, request hearing.
All right, is there, let me ask this, is there alleged to have been like audio recordings of these calls?
Yes, I was sent them this morning. It seems to be from October 13th.
From today? Wait, the calls were made today or?
The victim notified me yesterday. I was able to speak with her today. The voicemails that were left on her phone were from October 13th.
All right, so I've entered a not guilty plea for purposes of arraignment on the alleged violation. And then it's also my understanding that the defendant in this case may be intoxicated right now.
Your Honor, I've spoken with Mr. Haynes. I don't believe him to be at an intoxicated level. There are no bond conditions relative to alcohol. I indicate to him, I suspect the court may amend the bond conditions in that respect.
Yeah, no drugs or alcohol. Random testing. We have a breathalyzer in here.
We do, Your Honor.
I'm ordering him to take the breathalyzer. Just below the legal limit is a 0.077. Do you drive to court today?
He did
Don't
not.
answer.
No, he took it over. He was scheduled today for PSI, Judge. I would, in anticipation of the court's bond on the alleged violation, I'd ask that he be brought back tomorrow and a treatment court assessment be done as part of the PSI.
All right, well, we can keep him next door overnight. And then we'll see about what his bond will be for now. I mean, it's an alleged contact violation, which I go on ad nauseum about how they're not to have contact with the complaining witnesses, period. He has, and I understand these are dismissals, but they're contacts and charges that were brought. He has had 1, 2, 3, 5, 4, 5 different domestic violence cases brought against him. And that's incredibly concerning. So for now, he has a $15,000 cash or surety bond.
And he could be kept in Taylor tonight and brought back over tomorrow.
Yeah, we'll continue to, we'll keep him in Taylor for the night.
As allow the PSI to take place, treatment court potential referral.
All right, it'll be brought back tomorrow for the PSI.
Thank you. That's probably still.
All right, and we're on lunch. Mr. Ritchell on my 10:30 docket.
At 9:30.
He's at 9:30. Okay, that is. Oh, there it is. All right, this is 253051 FY, the people versus Anthony Ridgel.
I can do whatever I want to look at.
Oh,
Good morning, Your Honor, Nora Ali on behalf of the people.
And Judge, good morning to you. Michael Woodyard, P 64612, Neighborhood Defender Service. We represent Mr. Ridgel. He's here with me in court. Would you please say good morning and say your name?
Good morning, Anthony Ridgel.
Ridgel. All right, I see that. Has he been previously arraigned?
Sure, Judge. Mr. Ridgel told me that he was directed to you in person, so perhaps not.
Oh, he was. He was given a. He
Okay.
was arraigned out county. So, okay, so, as to, discovery counsel, do you have discovery on this?
I have just this morning been provided the police reports, the written police reports. I believe counsel will check to see whether video exists and forward it to me. I have no doubt that that process will work fine.
Yes,
Okay.
as soon as I was notified that he was the attorney, I sent over a discovery, and the digitals were also just sent.
Okay, okay, so we'll set this for an exam on October 20th. What time I have them scheduled for? I have them at 10:30 a.m. Does that work, Mr. Woodyard?
Yes, it does.
All right, wonderful. Bond will continue. We'll see everyone in person October 20th at 10:30 a.m. for the preliminary examination.
Judge, can I address a question of bond real quick?
Sure.
So the only issue that I'd like to raise is a tether that the out county magistrate apparently ordered Mr. Ridgel be fitted with. It creates a significant hardship in this way. Mr. Ridgel works, I can't even believe this, something like 4 a.m. to, he works super early in the mornings, 5 in the afternoon till 4 in the
Okay.
morning. He works the overnight hours.
Okay.
And so he's fitted with a tether. He's given the hours out from the house that are very limited. Because of the strange report to work hours, he finds himself having to get an Uber back and forth to work because he's moved away from the house where this incident is alleged to have occurred. He's living all the way over in Detroit with his mom, who's here in court, and his brother. So he has to get an Uber. It eats into his money that he can't use to help support his household. And so our hope, Judge, is that you'll strike the tether requirement.
All right. Well, let me say this. You got a gift because you were arraigned out county, because if I would have handled this arraignment or my magistrate would have handled this arraignment, you would not have gotten a personal bond. So I'm going to just be clear. With charges like this, you would have received a high cash bond from this court and a GPS tether. So, and I know your attorney knows that. On a home invasion, first degree, it's a 20-year felony. And there was a history of assaultive crimes on your record. I mean, like, this is not good. You've been given a personal bond by another judge. And if you comply with the terms of your personal bond and you don't have any contact with this complainant witness, I'll let you keep it. But the idea that I would remove a tether from someone who's got a prior conviction for aggravated stalking and I mean, that's insane. It's crazy. Receiving and concealing stolen property. I mean, the charges here are not good. They're assaultive in nature. He's got a prior assault and battery on his record. I mean, absolutely not.
Thank you, Judge.
All right, we're all set.
We'll be here on Monday.
You're welcome.